Hi, I'm Anna Denton-Jones of Refreshing Law Limited, and in today's session I'm going to be thinking about the topic of moonlighting, or what happens when an employee has a second job and some of the issues that might arise from that, particularly as we've entered a period where wages are not rising and employees may be feeling the financial pressure and therefore inclined to take on a second job or other duties outside of their employment with their main employer. The key concept that kicks in this area is the implied duty that's contained in everybody's contract of employment, whether or not it's written down, which relates to the concept of fidelity towards the employer. And Lord Woolf summarised how this works in a case of Attorney General and Blake back in 1998, where he said that the employee must act in good faith towards the employer. He must not place himself in a position where his duty and his employer's interests may conflict. He may not act for his own benefit, his own personal benefit, or the benefit of a third party without the informed consent of the employer. So the employee has this duty to their employer. They shouldn't be working for anybody else during a period of sickness absence, or perhaps on the weekends or in the evenings without that employer's say so. Now, a lot of employers will have provisions contained in contracts of employment that give a mechanism for the employee to inform the employer about their interest outside of work and to obtain permission for doing that. So, for example, if you employ somebody as an administrator, but in their spare time they have a wedding cake business, as long as you're happy that they are not going to come into work too tired to do their duties for you, you may well say yes, that you have no problem with them doing that in their spare time. But what happens where the employee is actually doing something in their spare time that the original employer is not going to be happy about? So, for example, the employee is employed at a hotel, and as part of their duties at the hotel they work in the health spa and they give beauty treatments. That employer probably isn't going to be terribly happy if they find out that the employee has been giving beauty treatments outside of work in their spare time. That would be breach of the duty of fidelity, and that employer would be entitled to take action to bring that employee's employment to an end. Now, we've talked about the contract of employment. Obviously, that employer needs to think about unfair dismissal. And if the employee has got sufficient service to qualify, then the employer is going to need to follow a fair procedure to bring the employment to an end, notwithstanding the fact there's been that breach of contract. So there'll probably have to be a little bit of an investigation and a disciplinary hearing and an opportunity to hear what the employee's got to say before that employer will be able to bring that employee's employment to an end. The second issue that kicks in this area is the working time regulations. Obviously, there's a limit on how many hours an employee should be working in a week, and unless you've got them signed up to an opt-out, that limit is 48 hours. And the regulations look at the work being done in total by an employee during the week, so it would add up the hours both done for you and the hours done perhaps in another business. So employers need to understand what employees are doing from that perspective. And it's really from a health and safety concern. Let's say somebody does some bar work in a rugby club of an evening. Are they then going to be turning up to work too tired the next morning to operate the machinery that you may be asking them to? And it's that kind of risk assessment really that the employer needs to do. If you've got any questions, please do email me. It's adenton@refreshinglawltd.co.uk. Thank you very much.